Welcome to Casa Academy Chapter 5, Part 6, where we will cover real estate brokerage activities and procedures. I am absolutely thrilled you're here with us today because we are tackling one of the most vital, foundational topics in your entire real estate career, and that's the proper handling of escrow funds. We're going to look closely at exactly what happens when you are entrusted with other people's money. It's a massive responsibility, and Florida law absolutely does not take it lightly. Mastering these incredibly strict Florida regulations isn't just about passing your Casa Academy licensing exam. It will certainly help you do that, for sure. But more importantly, it's about protecting the public out there in real-world practice. When you understand these procedures inside and out, you become a safeguard for your clients, ensuring their hard-earned money is handled with the utmost integrity.
Okay, let's dive into this. Here is our roadmap for today's lesson. First, defining escrow funds. Then, types of escrow deposits. Who holds the funds? Third-party escrow procedures. And finally, handling additional deposits.
Let's start with Section 1, defining escrow funds. What exactly are they?
Basically, escrow funds are funds or items of value held by a neutral third party on behalf of two parties involved in a transaction. I want to speak directly to you for a second here. When you are acting in this capacity, or your broker is, you do not own this money, not a single cent to it. You're just receiving and safeguarding that deposit until the contract terms are completely fulfilled. It is strictly held in trust.
Now, you're going to hear these deposits referred to by several different names out in the field. Buyers often provide an earnest money deposit or a good faith deposit to show they are serious about a purchase. But what's fascinating, and what you absolutely must remember, is that these rules apply way beyond just sales contracts. If you step into property management, you'll be collecting security deposits and advance rent. Same deal. Those funds belong to the tenant and landlord, and they must be placed into an appropriate escrow account and safeguarded the exact same way.
Moving right along to Section 2, types of escrow deposits. Let's clear up a very common myth right now.
Many people assume an escrow deposit must always be cold, hard cash. But that is simply not the case. A deposit can absolutely be cash, but it can also be personal property, real property, or honestly, any item that can be converted into cash. Oh, and for your administrative records, your verification code is 800159. Make sure you jot that down. Now, regarding post-dated checks, they are acceptable, but they come with a very strict caveat. You absolutely must have the seller's prior approval before accepting one.
So, the crucial point is this. What happens if a buyer writes a check for their earnest money and it bounces? Because, well, it happens. Well, if you, as the broker, properly follow all the required procedures for receiving and depositing that check, you are generally not held responsible if it's later returned for non-sufficient funds. Following the rules is literally your shield against liability.
Section 3. Who holds the funds? Let's talk about the actual escrow custodians.
In a real estate transaction, the broker certainly has the option to serve as the escrow holder, but they aren't the only option. The funds can also be held by a title company or an attorney acting as the escrow agent. In fact, because Florida's escrow regulations are so incredibly strict and heavily audited, a lot of brokerages completely choose not to maintain their own accounts. Opting for a title company or an attorney drastically reduces the broker's liability while still keeping those consumer funds perfectly safe.
That brings us to Section 4, third-party escrow procedures. We are entering highly testable territory here.
When a title company or an attorney holds the funds instead of the broker, the state requires complete transparency. The broker who prepares the contract must include 4 exact pieces of information directly in the document. You need the full name of the escrow holder, their address, their telephone number, and their email address. This isn't a suggestion, it's absolutely mandatory. It ensures everyone involved knows exactly who is holding the money and exactly how to reach them.
Let's move to and see how this builds into a complete verification process. Once you've got Step 1 done and the contact info is in the contract, Step 2 kicks in. The broker has to obtain written confirmation from that escrow holder, verifying the funds actually arrived. For instance, the title company might send over a receipt referencing file number 589991. That piece of paper is your golden ticket. Then comes Step 3. The broker must turn around and provide a copy of that confirmation straight to the listing agent.
And how long do you have to get that copy to the listing agent? 10. You have exactly 10 business days, not calendar days, business days. I really want you to heavily emphasize this number in your notes. The clock is always ticking in real estate, and 10 business days is your firm, unbreakable deadline to provide that proof of deposit.
Finally, Section 5,
Handling additional deposits.
Often, a buyer might put down an initial deposit right at the start and then agree to provide a second, additional deposit maybe a few weeks later. And this brilliantly illustrates the consistency of Florida real estate law, because additional deposits are treated exactly the same as any other escrow deposit. The exact same notification rules, the exact same documentation, and the exact same confirmation timing, yep, like our 10 business day rule, continue to apply to each and every additional deposit.
So, to wrap up our lesson today, remember this. Understanding the rules for documentation, notification, and timing is essential for both the licensing exam and professional practice. Whether you, as a broker, hold the funds or a title company holds them, mastering these regulations is the ultimate way to safeguard consumer funds, protect your license, and maintain the integrity of our entire profession.
But before I let you go, I want to leave you with a thought to chew on. We talked a lot about that strict 10 business day timeline today, so ask yourself, what do you think are the exact legal penalties if an escrow timeline is missed by just one single day? Florida's oversight is incredibly strict, and the consequences are real. Think about how vital it is to build flawless systems in your future brokerage so that a single day never slips by unnoticed. Keep that question in mind, and I will see you in the next lesson.